米国チームによる模擬裁判を行います。それではご登壇の皆様をご紹介させていただきます。裁判官役、米国国際貿易裁判所ジェニファー・チョ・グローブス裁判官。原告代理人役、ホワイト&ケース外国法事務弁護士事務所デイビッド・アルバグリ弁護士。被告代理人役、シュグルー・マイアン外国法事務弁護士事務所ファンディ・キブラウイ弁護士です。お手元のタブレットでご覧いただく資料は6番の資料、米国の模擬裁判スライドです。ではよろしくお願いいたします。
Okay, good afternoon. Council, we're here for a Markman hearing today. This is a preliminary matter. In the United States, we hold a bifurcated proceeding. We first do claim construction, which is a legal matter where the judge only looks at the claim construction. We usually do this proceeding several months before a trial. So we're going to do a bifurcated proceeding today. So Council, we'll first go into the Markman. Would you like to reserve any time for rebuttal today?
Thank you, Your Honor. I'd like to reserve a few minutes for rebuttal.
Yes.
2 minutes, please.
Okay. Granted.
The plaintiff will as well. Thank you.
Okay. So we're going to start, as I said, with the claim construction. We'll hear first from...
Thank you, Your Honor, and may it please the court. Plaintiff would like to reserve minutes at the end of this presentation for a rebuttal argument. With respect to the claim construction, we find that the term in Claim 1, the through hole, requires the construction by the court. Now, plaintiff's proposed construction for the term through hole comprises three aspects. First, the hole is an opening formed in the top plate portion of a lid. It is located outside the base end of a flap with respect to the center of the lid, and the opening is one through which air and water may be discharged, but solid foods may not be discharged. Plaintiff would like to emphasize that this construction of through hole addresses both the relative location of the opening and the ability of that opening to permit gas, i.e. air, and liquid, i.e. water, to exit the container while retaining solids, such as the food materials that would normally be kept inside the container.
Counsel, do you think that the size of the hole is relevant?
No, we do not, Your Honor. We'd like to emphasize that Claim 1 does not recite any size or shape limitation of this hole, and neither does plaintiff's proposed construction. Now, support for our construction may be found both in the claim language as recited elsewhere in Claim 1 with respect to, for example, the formation of the hole in the top plate portion of the lid in elements A and B, and also the position outside the base end of the flap with respect to the center of the lid. These two aspects of our claim construction are expressly recited in the claim language. Now, for our third aspect of this, which is to say that air and water may exit the container, whereas solids would not, is found in the specification.
Counsel, let me interrupt you there. Before you move on, you've mentioned the placement of the flap. You think that's relevant, but how about the placement of the hole? Do you think that that matters in this case?
Yes, precisely, Your Honor. It's the relative location of the hole with respect to the base end portion of the flap with respect to the center of the lid. And that's the way we believe that the claim has been set forth with respect to those aspects. And so we do find, for example, that the third aspect of our construction is amply taught to one of skill in the art through the specification. For example, in the specification at paragraph 19, we see that the through hole is provided, quote, to release an excessive pressure inside the storage container. And by that aspect, we see that the air would be released. And then furthermore, the specification continues, when the user wants to remove only the excess water through the functional use of this device, then we see that our invention also provides for the release of liquids. Now, if we could take a moment to look at defendant's construction, we think that the defendant has focused too much on merely the size of the hole, and that would mischaracterize our invention. And by overlooking that the through hole of the invention really should be thought of as its relative position to the center of the lid, then I think that supports our position. We'd like to reserve the rest of our time.
Okay, thank you. We'll now hear from the defendant.
Thank you, Your Honor. Thank you, Mr. Al-Bagli. Fadi Kablaev Shagrumayan for the defendant, Donkey Inc. Now, as Mr. Al-Bagli has stated, it is defendant's position that as properly construed in view of the specification, the claimed through hole must be of a sufficient size to allow water to be, quote, smoothly discharged at a rate that would cause splatter.
Counsel, let me interrupt you there. Where does it specify that the size of the hole is relevant? What's your support for that?
Sure. It's in the same paragraph that Mr. Al-Bagli has mentioned, paragraph 19 of the specification. So if you turn to paragraph 19 of the specification, it explicitly states that the through hole is designed to have such a size that the water inside the storage container can be smoothly discharged and the food can be prevented from being discharged.
But that doesn't specify particular millimeters or a specific size, does it?
To one of ordinary skill in the art, one would understand that the size being specified here is to accomplish a particular function. In this case, actually two functions. The specification provides both an upper limit and a lower limit for the size of the hole. Indeed, plaintiff's own construction recognizes that when read in view of the specification, the claim as properly construed does in fact have these size limitations. And these are sizes to accomplish, again, the prevention of food from being discharged, that's the upper limit of the size, as well as a lower limit that allows for water to be, as I quote from paragraph 19, smoothly discharged. And what Pony's patent is specifically addressing, the problem that's being specifically addressed by Pony's patent, is the prevention of splatter. Now, I think based on plaintiff's construction, both parties agree that the patent does not cover any and all holes, any and all through holes, that there are size limitations. The parties agree that these size limitations are not explicitly recited in the claim. Rather, applying the law of Phillips, the claims must, in all cases, be read in view of the specification with the objective of ascertaining what the inventor has invented. In this case, it's clear from the patent that the inventor is addressing a specific problem, a problem of splatter. To address this problem, the hole in of itself must be of sufficient size such that there would actually be splatter. This is reflected in paragraph 19 of the specification. If the hole was so small that water is not smoothly discharged, there would be no splatter. There is no problem in those scenarios addressed by the invention. So when reading the claim in view of the specification as a whole, it is clear that the objective being addressed here is in the context of where the through hole is of a size where water is discharged smoothly, i.e. at a rate that would cause the splatter problem. And adopting this proper construction, there would be no infringement because Donkey's product, the hole is tiny, with the primary and intended purpose of releasing exhaust. Water is not smoothly discharged. Through third-party testing, we can see that the water is discharged at such a slow rate that there would be no splatter, and therefore this falls outside the scope of the Pony purported invention. Thank you.
Okay.
I will reserve the remainder of my time for rebuttal.
Okay, thank you. I'll now hear rebuttal arguments.
Yes, thank you, Your Honor. Your Honor, as you just heard from Mr. Kiblawi and as we briefed this issue on the papers, once again we see that the defendant has emphasized and focused on the size of the hole and the fact that this somehow the smooth discharge should become a claim element in our invention. And to the point where this discharge, if the hole is not large enough, then the discharge would not cause splatter. And it is this precise point that we wish to rebut, and that is because the invention is also characterized, as we mentioned before, by the location on the lid and relative to the flap. That is the location of the hole and its position relative to the flap. So whether splattering occurs follows more from the position of the through hole in relation to the position of the flap. And now, we also don't have anything in the record as to what smoothly discharged means. So that's an unknown element here. But we would point out that the attempt by defendant here to bring that into the meaning of the claim is to import what is simply a preferred embodiment of the invention. And as we see, the claim itself does not recite any element with respect to the size or shape of the hole, and from that it follows that it would be wrong to import that limitation as suggested by defendant. With that, we turn the case back to you.
Okay, thank you. Is there any rebuttal?
Yes, very briefly, Your Honor. Thank you, Mr. Al-Bagli, for your comments. So initially, I want to point out that one of ordinary skill in the art, reading the patent in the context as a whole, would understand what is meant by the smooth discharge. It is the type of discharge that would lead to the problem being addressed by the patent, splatter. And yes, while defendants agree that the relative location of the flap base to the hole is also a limitation in the claim, in fact explicitly recited in the claim, both parties agree, and this is unrebutted by plaintiff, that the claim also, under its proper construction, includes unrecited size limitations. The basis for plaintiff's construction requiring a size that allows water to be discharged but prevents food from being discharged, the sole basis for that is clear, paragraph 19 of the specification. It is improper for plaintiff to pick and choose 3/4 of this paragraph to rely on for his construction while ignoring the word smoothly. That is a word that is critical to the context of the invention, and under the law of Phillips, when ascertaining what the invention is, there's no doubt this invention is about addressing the problem of splatter caused by a smooth discharge, and not simply any discharge, including a trickle discharge of water from the hole. Thank you, Your Honor.
Okay. Thank you, counsel, for your arguments. At this time, I will rule from the bench regarding the claim construction in the Markman hearing. The court agrees with plaintiff that the claim should not be limited to the size or the characterization of the flow rate of water, even though the specification indicates that this may support the smooth discharge of water. The use of the term smoothly discharged does not suggest that a certain flow rate is required for the discharge of water to be considered smooth, only that the water should not hit the flap when discharged, regardless of the speed or the flow rate of the fluid being discharged. In the context of the specification, As a whole, a person of ordinary skill would read the claimed through hole to have an opening wide enough to allow for the discharge of excess water to not hit the flap of the lid. The discharge of water occurs when the storage container is enclosed with the lid and tilted to remove the excess water from the opening at the corner of the top plate portion. In addition, the parties have not provided any extrinsic evidence in their arguments for the construction of the claimed through hole. For the foregoing reasons, the court construes the term through hole to mean an opening formed in the top plate portion of a lid, located outside the base end of a flap with respect to the center of the lid, through which water may be discharged, but solid foods may not be discharged, where the water does not hit the flap when discharged from the storage container. So ordered. And now we'll move several months later, and we will proceed to the invalidity portion. So my first question, counsel, is have you discussed settlement? And what is the status of any settlement talks at this point?
Yes, thank you, Your Honor. We have attempted to settle with defendant. We've had numerous missed calls, and we were able to speak directly once, but we have not reached any settlement yet.
Do you have a response?
Yes, it is the position of defendants that plaintiff's demands are unreasonable, and we have not reached a settlement as of yet.
Okay, so you'd like to proceed today? And we're proceeding with a bench trial, correct?
Yes, Your Honor.
Yes, Your Honor.
All right, so I'll now hear from the parties on invalidity arguments.
Thank you, Your Honor. Again, Fadi Kiblawi for the defendant, Donkey. So defendants submit that one of ordinary skill in the art would have found the asserted claim of the pony patent invalid as obvious by the patent's own admitted prior art, either alone or in combination with the U.S. 2006 prior art reference. Indeed, there is no dispute that the admitted prior art discloses all of the elements of Claim 1 other than the location of the flap base relative to the through hole. The purported invention simply makes a trivial and simple rearrangement of these parts such that the flat base is moved from inside to outside of the through hole. Yet it is well settled in the case law that the simple rearrangement of parts in a manner that does not modify the function or operation of the constituent elements of the base device is an obvious design choice. In this case, it's indisputable that there are a finite number, 2, of relative locations of the through hole and the flat base, either inside or outside. It is also indisputable that rearranging these relative locations would not affect, modify, or otherwise disturb the function of the storage container, the function of the through hole, and the function of the flap of the admitted prior art. Thus, Pony's asserted claim would have been obvious as a matter of design choice in view of the admitted prior art. Now, notably, under the supreme law governing obviousness, that is, the Supreme Court's decision in 2007, KSR versus Teleflex, a finding of obvious no longer requires an explicit teaching, suggestion, or motivation found in the art. Instead, and I will quote the Supreme Court here, if a person of ordinary skill can implement a predictable variation, Section 103 likely bars its patentability.
Counsel, do you think that KSR overruled Graham? Is Graham still good law?
Graham is still applicable law, and the factual findings under Graham are also applicable. And in this case, the factual findings under Graham would also yield, together with the articulated rationale to support the legal conclusion of obviousness required by KSR, a finding of invalidity. Now, under Graham, we look at the differences, for example, between the base device and the claimed device. In this case, There's one difference, as we mentioned, the relative location, the arrangement of the through hole versus the flat base. In this case, the prior art establishes that rearranging the flat base inside of the through hole is not just, quote, a predictable variation, but a known variation. US 2006, on the right-hand side of the screen here, as one example, shows this known variation in the art, whereby a storage container flat base is arranged inside of the exhaust hole.
Would you like to reserve any rebuttal time?
Yes, Your Honor.
Okay,
1
then
minute.
I think we're at time if you're going to have rebuttal. Would you also like to reserve rebuttal time?
Yes, please.
Okay.
With respect to the validity issue, plaintiffs would like to rebut both of the grounds that have been raised by defendant for allegedly finding our claim to be invalid. With respect to ground one, in which defendant alleges that actually the disclosure made in the specification would render obvious our claim. Now, it was characterized as a mere rearrangement of elements that were found in the prior art and admittedly which were written in the specification. We find that defendant has not articulated a reason for why one of ordinary skill in the art would have been motivated to change the structure of that prior art device in order to achieve our claimed invention. With respect to ground two, which defendant reached, which is the combination of what was written in the specification and as just discussed, with the prior art reference, US reference 2006. And with respect to this proposed combination of prior art references, the defendant has not established a prima facie case for obviousness because plaintiffs respectfully assert that the combination would have rendered the prior art inoperable or unsatisfactory for its intended purpose. And I'm speaking specifically with respect to the flap that is activated in that reference by use of a vacuum. We also point out that defendants' arguments are based on hindsight reasoning, and it is only by seeing the plaintiff's patent specification that it had come up with this reason for bringing these two references together, and that is not permitted under the law.
Wasn't there a commercial motivation?
That's debatable, and we find that there's not necessarily one. In fact, with respect to that particular issue, the prior art container that was disclosed in our specification was well known in the art. This had been used for many years, and in fact, the flap itself was located at the edge of the lid for manufacturing purposes. That was the way that it was easy to manufacture. And taking these two issues into consideration, we find that defendant's argument is merely superficial. Taking the flap from one position to another, anyone can do it. Defendant makes it sound like a child could have redesigned this. However, we wish to point out again that the flap was located at the edge in this prior art device for ease of molding, for manufacturing reasons. And to a person of ordinary skill in the art, this alleged modification would have required extra work and greater expense for little apparent reason. Now, we agree that, of course, Deere and KSR are good law, and that KSR has done away with the need to expressly find a teaching, suggestion, or motivation. But nonetheless, case law still requires that in order to allege this invalidity, there must be articulated reason why the change would have been made. And we have not heard a sufficient articulation of that reason.
If you'd like to reserve time,
Yes, Your
we're
Honor.
at
Thank you.
time. Okay, thank you. Okay, you can have a little under 2 minutes, counsel.
Thank you, Your Honor. So to plaintiff's point that the ground two, modifying the admitted prior art to rearrange the relative location of the flat base, that would render the device inoperable for its intended purpose, that's categorically false. That would be relevant if we were looking at the US 2006 prior art reference as the primary device. We're not. we're looking at the admitted prior art. And when you rearrange the location of the flap of the admitted prior art to a, again, not simply predictable variation, but a known variation, as shown in US 2006, does not impede, disrupt, or otherwise affect the operation of the device. In terms of the KSR's requirement of an articulated reasoning with a rational underpinning, well, KSR recognizes that a simple substitution of one known element for another to yield predictable results is sufficient as a reasoning articulated with the supported rationale for obviousness.
You have 20 seconds left, counsel.
Thank you. So I simply ask the court to apply the law of the Federal Circuit in Apple versus Samsung. Just as in that case, also here, when a patent simply arranges old elements with each performing the same function it had been known to perform and yields no more than one would expect from such an arrangement, the combination is obvious. The simple substitution of one known element for another makes Pony's patent and their asserted claim obvious. Thank you.
Okay. Thank you. You can have about a minute and a half. Yes.
Yes, thank you, Your Honor. The point that we would like to rebut is with respect to the prior art reference, which uses the vacuum in order to activate the flap. And to the extent that the defendant believes that we're going to just rearrange this, I'd like to point out that one second here. Right, that what the defendant has proposed is hindsight reasoning, basically, and that the conclusion of obviousness must be reached on the basis of facts understood from the reference itself. And if we look back at the reference and where it's using a vacuum, it is simply put this flap inside the area of the lid so that the vacuum can be located on top of this and not be interfered. And so this is inapt. It doesn't relate to the reason for moving the flap from the edge of the lid that's in the admitted prior art. And for that reason, we find that there's no motivation that's been articulated here. Thank you, Your Honor.
Okay, thank you. Thank you, counsel, for your arguments today. Also, I normally would take this back and write a full opinion on this. Today, I'll make an exception and we'll rule from the bench. So the question before the court is, was it obvious to a person of ordinary skill in the art that a combination of the two prior art references would resolve the issue of removing both excessive water and air pressure from the storage container after it has been heated? So the court concludes that the combination of prior art references would not have motivated the person of ordinary skill in the art to modify with a flap based on a non-return valve for the claimed invention, or to move the placement of the flap further from the upper surface of the top plate surface. As there is no prima facie case of obviousness or further evidence of secondary considerations, the court, having considered the defendant's asserted prior art combination and the evidence in addition to plaintiff's argument of non-obviousness, concludes that the defendant has failed to prove by clear and convincing evidence that the asserted claim of the plaintiff's patent would have been obvious. So for the reasons stated, the court holds that the plaintiff's patent is valid under 35 U.S.C. Section 103, and the defendant's product directly infringed plaintiff's patent. Thank you. Thank you.
以上で米国チームによる模擬裁判を終了いたします。ご登壇の皆様ありがとうございました。